Good morning, everyone. It is my immense pleasure to welcome you all on the last day of our 1 month faculty development program organized by Faculty of Law, Integral University, Lucknow, with the Association of Indian Universities under the aegis of Human Resource Development Center on the topic of integration of intellectual property rights principle into teaching, research, and professional activities. Today, we have our fifth and last session of Module 4 on the topic of Open Education Resource and IPR. We are honored to have with us a remarkable individual who has made significant contribution in various fields of law, Professor Dr. Girjesh Shukla sir. Dr. Girjesh Shukla sir, after graduating from the University of Allahabad, pursued his Masters of Law and PhD from the University of Delhi. And before joining the Himachal Pradesh National Law University, Shimla, Sir has taught various law schools also. Sir has delivered lecture talks at various training centers, including Police Training Centers, New Delhi, Jharkhand Judicial Academy, Ranchi, Himachal Pradesh Judicial Academy, Shimla, SLS Hyderabad, Lloyd Law College, Noida, etc. Sir has completed UGC minor projects on the topic of compensation to victim and judicial mechanism, an alternative approach for access to justice. Sir has also been associated with the Supreme Court project on restatement of Indian laws, public interest litigation. Sir has authored 7 books, including Criminology, Handbook on Criminal Procedure and Tax Law. Sir has authored many research published paper in national as well as international journal, and also presented research paper at national and international conference. Today, we look forward to his valuable perspective and the practical strategies he will share with us. I encourage all of you to take full advantage of this opportunity to learn, ask questions, and engage in discussions that will undoubtedly enrich our professional journeys. So please, without further ado, please join me in extending a warm welcome to Professor Dr. Girjesh Shukla sir. Sir, we are excited to have you with us. Now, over to you, sir, and the stage is yours. Thank you, sir.
Thank thank you, Dr. Tolika. I think if I'm audible, please confirm. Okay.
Yes, sir.
So thank you so much. And if you can, put that, PPT
Yes, yes,
also.
yes, yes.
Thank you. Thank you so much. First of all, congratulations to the organization and the organizers both for choosing this topic. Hardly discuss at such a wider label in our organizational setup. We assume that the researcher, the academician, and the people, they are fully aware of the interface of intellectual property rights and the teaching, learning, professional activities. It will not be exaggeration if I say we take it for granted. The IPR things in our teaching and profession, we take it for granted. We don't look into what are the nuances of IPR, how IPR is going to affect our teaching learning process, how ethical it would be if we do not consider the intellectual property right in our teaching. All these aspects are often either ignored, or even if not ignored, misconstrued. We assume for granted, as I said, that if somebody has written book, it's all our right to read it, to quote it, to repeat it, and sometime to distort it. It is also a kind of scenario. I remember I'm a kind of disciple of University of Delhi, where professors used to in every second paragraph used to quote the name of the author. I remember the lectures of Professor Upendra Bakshi, Professor Kamla Shankran, Professor Alka Chawla. These are the legends in the field of law, And I've seen how careful they have been in their lectures, in their write-ups, in their kind of study material which they supply, how careful they have been to recognize, to give adequate credit to the professors, to the researchers, to the contributors, when as and when they used to take up their material in during the lecture. This reminds me not only kind of ethical aspect in lectures, in research, and in professional activities also. It reminds me the kind of culture which is required to be developed in the academia. uh, Not to, as I said, not to take it for granted any work done by anybody else. And to begin with, when I was in process of writing of my very first book on criminology, I remember I was privileged enough to have the guidance of Professor BB Pandey, and he told me that if you require to quote, say, 10 to 20 author in one page, don't hesitate. If it is not yours, if it belonged to somebody else, don't hesitate in quoting. There is no wrong as such. And I remember during my LLM, when he was teaching me, he, along with many other professors, they used to share the documents, especially the articles and research work from the Harvard Law Review, from the Cambridge, from other renowned, institutions. And I used to see, and I would encourage all of you to at least go and see the publications of these institutions. You will very soon see that on very first page of the article or research work, if it is first page or second page, you will see only one or 1.5 paragraph is there on the page written by the author. Rest all are the footnotes. Repeatedly on every paragraph you will find n number of footnotes. Whenever they borrowed any idea, they quote it without failing. Unfortunately, uh, I may be excused, majority of the organizations, educational institutions these days, which we see, we interact, the authors used to write down, say, 20, 10 to 20 page, 30-page paper. And if you see how many footnotes are there and how many effective footnotes are there, how many credit has been given to the authors or to the researcher or to the other people to whose statements, etc., they are using, you will see that they are minimal. They are minimal, as if that quoting more and more footnote would credit or discredit their authorship or discredit their research attitude or acumen as such. Not at all. That is not the case. So with this kind of observation, when I was preparing the presentation for this particular event, I thought to put this as a caveat, that we should learn IPR not merely to deliver lecture in classes. We should learn IPR not merely to understand what IPR is, but to imbibe the principles of IPR, intellectual property rights, as part of our ethical code of conduct. With this, let me begin with my presentation. In this presentation, you will find out a kind of interaction between an IPR, the teaching and research, as well as professional activities where the IPR could have an intersection. And then I will also have a kind of the exclusionary approach in the intellectual property rights, where the claim of IPR related rights have been to some extent taken, given a back seat, and people have been authorized to use the intellectual property rights of other without any problem as such, without any restriction as such, which you can preferably call the open educational resource system, the OER system. Okay. So this in this particular chapter, in this particular presentation, I will interact with you on these issues, and then at the end, I have also added some practical aspect through the case laws, that when and how the non-observance of IPR rights can enter into, can put you in a sort of very difficult position, especially in terms of your career growth, especially in terms of your professional growth as such. So to begin with, IPR rights, what exactly they are, just a one liner here, that basically it is a kind of right granted to the creator and the inventor to protect their innovations. It's basically nothing but recognizing the worth of your creation, and this worth is recognized not from some sort of mere ethical concerns, but commercial concerns. When I create anything, when I created a book, when I created a drama, when I created a picture, when I created any sort of marks or maybe design, I have created that with a specific purpose of not only as my own intellectual satisfaction, but also in future exploiting the economics of that creation. That is the major concern, because of which the whole umbrella of IPR right came into existence. It is a kind of protection, intellectual property rights. It's a rights which is created in your intellectual property, and that's how this whole nomenclature itself so nicely given. Now, as far as the legal framework is concerned about the intellectual property right, we have the Patent Act, we have the Copyright Act, we have the Trademarks Act, we have the Design Act, we have a Geographical Indication of Goods Registration and Protection Act 1999. These are the umbrella legislations which collectively protects the intellectual property rights of the creator, of the innovator. Now, these legislations are also supplemented by the government's initiative on intellectual property rights. So we have a national IPR policy 2016. We have a lot of programs like SIPP, scheme for facilitating startup intellectual property protection, accelerated examination for startups, and IPR awareness campaign in universities and MSMEs. We also have a specific IPR related innovations in the entrepreneurship and indigenous manufacturing. And if you are coming from the investment and security laws, especially if you are aware about the SEBI regulations, you will come to know that if you are a startup, if your company is engaged in IPR related works, there is a separate window for a listing of such startups and companies on a stock exchange, what we call as different kind of not main board, but intellectual property or other related boards. So there are different things. So in fact, point is that the government of India is not only protecting, having taken effort to protect the IPR right, but also promoting the very IPR right in different field, beginning from creation to that of economic exploitation of IPR rights. Now, with respect to the IPR, why before I come to the teaching and research and professional activities, why we see that there are certain issues cropping up on daily basis with respect to IPR in India, because of certain reasons, probably and primarily four reasons. First of all, IPR related awareness in India is minimal. We least care about that as such. To put it in a very light manner, on a lighter note also, if you enter into any salon in India, whether it belongs to Lucknow, Gorakhpur, or Shimla, or Delhi, you will find the hairstyle through which is depicted through the actor and actress. And if you ever ask whether that hairstyle or the person or the designer who has created that hairstyle for a particular picture or particular movie, have you taken any permission? Or do you think that that particular picture or that particular kind of hairstyle is in an open domain, commercially could be used by anyone? Probably people will feel unaware about it and they would say, I have not done any wrong in that regard. I've seen that movie. I saw this picture outside in the market and I need the same hairstyle, same, kind of fashion also, same kind of clothing style, same sort of, other kind of dramatism and all, without bothering that this creation is having some intellectual property inside it. And one is not required to invade that right, because invading an intellectual property right is as good as any other offense, something like, stealing somebody's property, committing something like theft or dacoity or robbery. So, this is the concern. The first one is that we are least aware. IPR awareness is very minimal. The second one, even if somebody is a creator, the second problem with respect to IPR is the very recognition of that IPR through the legislation or through the administrative mechanism. I will quickly wrap up because this is not the main concern of my today's interaction with you. The third one is limited IP enforcement. The IP related enforcement is again a very minimal. It is, as I said, taken for granted not by the people but also from the administration side. And the last one, inadequate IP commercialization in India. I have not come across till date a single, setup which provides me an easy opportunity of my creations, except in publication department or except in the some sort of software departments where designs etc are protected and easily there is a easy availability of commercialization of those designs. Rest in all other fields hardly we see any sort of commercialization. So because of those four reasons which I have discussed in the last slide, because of that those four reasons, we do not see much scope of IPR development or IP related developments in India. Now, in what way IPR interact when, as a teacher, we deliver lecture, when as a teacher, as a researcher, we go for research works, when as a professional, especially I belong to a field of law, what if my student who is there tomorrow joins advocacy, tomorrow joins any sort of corporate office where he's supposed to prepare the brief, supposed to prepare the documents, supposed to prepare a case note and all, to what extent that is also interacting, the IP rights are going to intersect or interact with these people. To put it in a more formal manner, the copyright in educational material is the most important aspect of IP right when we talk about the delivering of lecture or research. In copyright, as we know that ownership of the original work, whether it's a note, whether it's a presentation, whether it's a lecture, the same is protected under the Copyright Act. The protection of digital content online etc through the preparation of lectures, PPTs, MOOCs etc, all are having some intersection. And if you read the Copyright Act itself, if you go through the provisions of the Copyright Act, in what cases infringement could be there, section 13 etc, in what cases even without infringing the copyright you can use the intellectual properties of other, which falls under the domain of what we called as fair use doctrine, where the exceptions are being carved out for educational purposes with certain limitations. So all these intersections comes when you enter into the field, enter into the domain of the IPR, as a lecturer, as a teacher, as a professor, or as the case may be. Now, when you interact in the teaching as such, the kind of IPR intersection could be the content protection. If as an educator you are developing any unique teaching material like textbook or online courses, the IPR rights intersects and ensures that these materials are protected against unauthorized use. So one is this particular intersection comes from the point of the creator himself or herself. Since it is given a protection, so logically there is a incentive to create. If since it is going to be recognized as your own creation, since it is going to be recognized as commercially viable creation, there is an incentive to create that. Teachers are more motivated to create innovative and high quality educational resources, knowing that it is their work and the IPR rights protecting the IP law protects it. Access to resources, it is also become very important from the perspective of IP intersection, that the proper licensing will allow others to legally use the diverse material, enriching the learning experience. The ethical teaching is also become part of IP intersection. Teaching IPR raises awareness among students about respecting others' work and the legal use of information. And in fact, it would not be out of context to quote that when we prepare study material at NLU Shimla, or when I got educated from University of Delhi, I could see that every material distributed to us were having proper acknowledgement at the top of the page itself, that who is the author, who is the creator, who is the editor of that material, without failing. In fact, I may share with all of you that from this year onwards, uh, the NLU Shimla has created the e-copy of all the study material, which is supposed to be taken up by the teacher during the 6 month semester, and that is required to be distributed in advance. We used to earlier do what, that we used to just download any paper from the website which we feel it is interesting and it is important, and we used to share it with the students. Sometimes these paper used to run in 200 300 pages. So our vice chancellor, of visiting vice chancellor Professor Chanchal, told us that can we do something that we can reduce the number of pages so that the students having 6 subjects in one semester can read it. It's a very interesting story. So all teachers decided that edit we will edit the paper which we are going to distribute to the students for the purpose of their learning and their studies, so that they can have a lesser burden in reading those 200 300 pages research work. A very interesting question was, it was raised by all of us, in fact 2 or 3 of us immediately, that sir, you are saying that we should edit the write-up of any author published in Harvard or Cambridge or any Delhi Law Review, etc. How can we edit that paper? We cannot edit. Even in the name of fair use, if we are going to edit it, we will be distorting the very publication. So we come to a very important conclusion in the fair use doctrine after consultation of professional in this regard, that we should not change the paragraph. Rather, we should write down our own notes above the or beside the pages, and keep the relevant paragraph in the same manner without changing any comma, inverted comma, nothing. Because that will tantamount to editing the paper for which we are not authorized. Even if legally one can argue that this could be a case of fair use, but we are basically distorting the paper written by somebody else. If we can think from this perspective, if we can think that okay, we can go to respecting the others intellectual property to that extent, then probably I believe then it would be a great way, a very fair way to deal with the intellectual property intersection with and while you are teaching or doing research as such. Point is that we need to respect the creation of others. Now, when we talk about IP violation, in what manner it could be violated while engaged in the teaching? Unapproved textbook copies. You are allowing photocopy of books without having any such permission, and that too distributing the copies, sometime full chapter, sometime entire copy without having any permission, and that too on a commercial basis. I, for one, have a kind of exception here. If organization is charging, if the teacher is charging any amount in the name of study material, and then simply photocopying all other work of others, compiling it into one study material and distributing it and charging it also, it is commercial exploitation of others' intellectual property without license, without having permission, which is again a violation. So one way often ignored by us is simply allowing the people or sometime even managing it on our own to go for a bulk photocopy and then distributing it to the students in the name of fair use. Fair use is not as such for all these purposes. Second one, unauthorized course material sharing or uploading copyrighted lecture notes or presentation on public website without author's consent. Third, unlicensed software use. Many times we use software of others unlicensed. And to be very honest, I will not name majority of the institutions. If you see whether they have purchased licensed version of Microsoft Office or Windows or even the PDF editors, you will find that majority of the cases they do not have licensed version. And because of that reason, what happens that we engage in the process of IP violations, even in teaching. Copying online content using image, videos, or articles found online in presentations or assignments without proper attribution or permission. Now, here one thing is required to be understood. When the material is available freely or when the material available as part of license, then there is no question of non-using it. You can use. But when it is not so available, one must take the permission or a valid license. I you may not ask me a question, but you can think of that what I am doing here when I have used an image. I have not shown anything here that from whom this image has been taken. I can take it for granted because this image is a creation of MS Office PPT designer. I have not done anything. It's a licensed version in my computer, in my laptop. And through that licensed version, there is a designer, and this designer itself has designed the PPT. I'm not very good in designing PPTs as such. But I'm taking this help and I have paid it. I mean, for that purpose, some 6 to 7,000 rupees annually. This is not so costly. Unfortunately, majority, I have seen majority of the people, they do not take licensed version and often trap into a kind of with a attitude of advertently doing things, copying others things and violating the IP rights. Third one is plagiarism. Plagiarism is these days one of the major concern of teachers, researchers, organizations, and even the regulatory bodies. See, for example, the plagiarism and related regulatory framework is nowadays not only getting strengthened with the UGC on daily basis issuing directions and having a regulation also in this regard, where the copies, research works, research papers, they are put to the test, Turnitin or other kind of softwares available. Orocond earlier it was. Now they have UGC has adopted another uh, Delbret and all, and they are now put to use for the purpose of having check on the plagiarism related aspect. People are copying the material of other, even if they are citing it, even they are giving the footnote. What will happen when entire material is copied from say 10 to 20 sources and nothing original, no originality, no nothing out of there? What is the purpose of that kind of intellectual exercise? So this is again a section where IP right interfaces interact with the a kind of what we call as teaching and research work. Improper use of educational videos. Suddenly, in the era of booming of technologies, I have seen that lot of teachers used to send YouTube video, whether it is permitted or not permitted, whether it can be used or not, to extremely excessively in their lecture. And many times they believe that they can replace their original lecture, they can replace their interaction with the student through that of the video. Video can be supplementary, and even if it is there, it must be sent with a proper recognition. Otherwise, it is again could be a question of, as I said, till date it is not having a proper implementation, but tomorrow it may. And in those cases, it can result into a lot of legal complications as well. Replicating text test materials, reproducing standardized test or exam questions from copyrighted sources without authorization, online course duplications, repackaging and selling online course material created by others, other educator or institution without permission. I will not name here again. One of the very leading university has adopted, taken into consideration entire study material of Delhi University and circulated the same by changing the cover page to their own student. Can that form the exception of fair use? These are the illustrations. These are the instances where the IP intersections, to be more precise, IP violations are being done as part of teaching and learning exercise. Now, in case of IPR in research, patentability of research output, understanding what constitute patentable invention in India is important understanding. As a researcher, you must disclose about the innovations to the institutional IP cells. If it is there, get the protection from the organization. Patent filing procedure is there, you need to apply for that. Or whatever procedure is prescribed in the Patent Act 1970. Similarly, if you are engaged in collaborative research, safeguarding IP in joint ventures or institutional industry collaborations is important. Importance of research agreements. Here also, I need to emphasize. Many times I have seen that funded research are being given to the people. Grants have been received by the researcher. And later on, after submitting the research work to the concerned institution, organization, or the funding agency, the said work is frequently used and commercially exploited by the author without permission of the funding agency? Can it fall under the domain of what you can call fair use, or can you claim that as of your own if it is funded? Borrow at least one illustration, one instance from the typical, well organized IP protection system. I was reading a research paper written by a Nobel laureate, and the very first footnote in which his name and designation was mentioned, there was a line that this work is an extract of the already conducted research work funded by such and such agency, and the extract has been prepared here after having due permission of the funding agency. This is the kind of and quality of ethical standard which is required. Publication of a publication and copyrighted work, again, as I said earlier, that you know research work, research papers are required to be going through with that copyrighted protections as such. Now, IPR during research writing is, as I said during the lecturing, there is a one shot of research work which is required, IP intersection required. During the research work as such, kind of different set of IP intersection is there. And in case of writings as such, we have already discussed about that. But at least two aspect is important here. The importance of IPR when we talk about research writing, it basically prevents the unauthorized use of your work. And secondly, facilitate the commercialization of innovation. If you remember, in the beginning of my interaction with you, I said, ultimately IPR has a commercial input. And that commercial input should not be forgotten. I was talking about plagiarism, how plagiarism and infringement concerns are now, as such, cropping up, coming up on daily basis. Presenting somebody else's work as your own is a major violation of academic integrity. And highest concern is there with respect to the plagiarism. Here, what you do, basically, the author used to do kind of unauthorized use of copyrighted work in his or her own work without any permission, due permission from that. How you can prevent that? Properly cite the source, all sources, use copyright free or license content, image ho, data ho, whatever is there. Use only when you have the license. Recently, I was engaged in submitting a chapter which is supposed to be published in the Springer kind of edited book. And it that reminds me again the ethical and legal concern of IP intersection. When I got prepared all the entire chapter and I sent it for the publication to the company, to the editor, I receive a reply that, sir, you have used two images. Kindly provide the authorization letter from the to online website through which you have taken up that image. That image was basically a very nice timeline published on one online website. The website has published information which talks about timeline of a particular development. It was related to environment. So I had to write a mail to the concerned website, and the reply I received, I submitted the reply to the concerned publisher, the Springer, so that that matter may be uh, pushed further. Point is that these are the very small things. I did nothing. Send an email to the website that I have used. I intend to use, in fact, I intend to use this particular image in my research work. Kindly provide license, and I'm ready to bear any kind of cost if applicable. And I received reply that you are required to permit it, required to use it, and the same is permitted. However, commercial use is not permitted here. I understand. Accordingly, the reply was taken. Point is that these are the concerns which, as a teacher, as a researcher, as a writer, we need to understand and appreciate rather. If you're using a copyright free document, no need to use. But again, citing that material is the minimum thing which is required. So even if it's a copyright free material, you can use it without permission, but citation is required because that will be falling under the plagiarism and similarity index criteria. Fair use doctrine, if applicable, use the material accordingly. Now, if you're doing a collaborative research, especially as I said, you are part of some agreement with the some agency, some other kind of organization, some other kind of institutions, there also try to have an agreement that what kind of intellectual property protection will be available. For example, if you are working with ICCR, ICSSR, if you are working with any other agency funding as well as other organization, what kind of IP right is going to be there? I do not know how many organizations have, especially the universities and colleges, permitting the IPRs, permitting research in their organization, have actually created an IPR cell or have actually published an IPR policy that if their teacher, if their or researcher, if their LLM student, PhD student end up writing any research paper, what kind of IPR protection will be available to the author, to the university or the college organizations? And what if the organization enter into a collaborative research with some sort of other organization, ICSSR or any other UGC? What kind of IP intersection will be there? To my surprise, majority of the organizations have never published the IP policy. If you wish to see IP policy, you can go and see the well-established organizations as to how they prepare a full-fledged document. I remember a few years back when the very first PhD scholar, and I happens to be the supervisor of that PhD scholar, completed and got awarded the PhD degree. He came to me that, sir, I wish to publish my PhD thesis. I said, the thesis is submitted to the university. You need to take permission from the university. And when I inquired about this, I came to know that my university has by that time not prepared the IPR policy in that regard. So we prepare the policy, and accordingly with that policy, the student was permitted and he has published his thesis. These are the things which result into more so like a caregiving to the research work and sense of belonging, sincerity, and also possible commercial exploitation. What if it is not going to be there? Then probably who knows tomorrow what kind of legal complication can come into picture. So the first thing is that if you are having any kind of arrangement with some other organization, enter into a proper agreement with respect to the non-disclosure agreement, with respect to the IP ownership, with respect to the co-authorship, whatever is there, you need to look into, so that these things may not be anyhow complicated in future. uh, as I said, that these are the areas, and because of my own public life in the field of research and other things I have come across, I remember when my two books, the criminology and tax law book, were published by the LexisNexis, I received almost this bulky document in 3 copy, in triplicate, to be signed by me and the author and the publisher. And then only I was going through with the detailed line of things. What kind of clauses are there? I do not know. But I would suggest strongly to all of you, you all are in the academics and research, please get a copy of publication agreement and read it for once. What kind of IP intersections are there can be beautifully understood by reading those agreements. And especially if it's a standard agreement like agreement of companies like Sage, like Springer, like Lexis, etc. You will find that they have a detailed guideline with respect to authorship, the ethical right, the moral right, the editorial power, the commercialization of the rights, and so on and so forth. So these agreements are important part of your overall IP intersection as a teacher, as a researcher, as a research writer, etc. Moving further, as I said, that there are two ways of possible intersection between the research, teaching, professional, advice on one hand, and the IP intersection on the other. One is that you are having an open access, and the other one, the traditionally published material. We all know traditionally published material we have already looked into. If it is already traditionally published material, you need to look into for the citation aspect, you need to look it for the copy aspect, commercial use aspect, or even some sort of you know editing or change related aspect. One thing which probably I would miss if I'll not explain here, that when we talk about copying any material, please remember, copying always reflect the copying of entire expression. Copyright Act protects the expression and not the idea. This line is very important to be understood. The famous R.K. Anand case is very lucidly explaining this idea, that what is the meaning of idea and expression. You are free to borrow the idea of anyone. And to put through an example, the Ramayana, the story of Ram, is and has been explained in a different ways. Somebody was telling me, though I'm not very expert of that area, somebody was telling me that more than a dozen type of Ramayana exist in India. The Balmiki has written one Ramayana, the Tulsidas has written Ramacharitmanas, and some other kind of Ramayana are written across states. Different states have different type of Ramayana. Story is the same, but their expressions are different. None of them can say you violated my copyright. None of them can say, even if copyright, assume for a while it existed at that in those days also, none of them could say that you fall under the category of plagiarism, because they borrowed the idea but without borrowing or copying the expression. So copyright protects the expression, not the idea. So you can begin with, you can take anybody's idea by proper attrition, by proper citation. But if you are copying it, it will fall under the what we call as a plagiarism or similarity index, and that may be tomorrow a subject matter of very critical, legal complication. So this is important one, that copying and copying idea and copying expressions are two different things which we need to take care. Moving further, in case of traditional copyrighted material, you need to take a license, as I have said in the previous slide. But if you are lucky enough to explore these days a new type of concept which has come, that is known as the Creative Commons, that is copyright free material which you can use without any proper much deeper, much formal licensing as such. What they are, I'll explain in next 2 3 slides. Through these Creative Commons, You can borrow the material, you can use them, you can to some time even make certain changes also. I'll explain those things in the next slide. But these Creative Commons websites, resources, they are providing huge material. And as a researcher, as a lecturer, as a teacher, it will be very, very useful for you if you can have access to these material for your teaching, research, and other purposes. How it works, that's interesting. Usually what happen that people these days, uh, to begin with that, I need to just go back a little bit in the history. Earlier, people used to say that it is my intellectual property and it should be used by others only by a proper license, permissions, and through the commercial aspect. A new web of thought started somewhere during 90s, that intellectual wisdom, intellectual creation should be made available freely to all, and the commercialization aspect should be limited, because by that way, if you are limiting the commerce in the name of commercial exploitation, if you are limiting the access to the intellectual material, that probably hinder the growth of civilization. And to address this concern, lot of authorship, lot of papers are being published, and it was a kind of web which was created, that intellectual property, intellectual wisdom, intellectual discourses should not be put in the barracks, should not be put in the cabins, should be put on free use. And that's how this whole idea started. But again, as I said, commercial aspect was not left completely outside, not rejected completely outside, it was taken a bit into that. So how it start? How the Creative Commons, popularly known as CC, Creative Commons, uh, it's a nice. There are two CC. One is cut, copy, and then PP, paste and produce. CCPP, which I office informally use in my class. CCPP. Another one is a CC proper, the Creative Commons. What does it mean? The generator of the creator of intellectual property, they enter into sort of licensing setup, whereby they provide whatever contributions are there, they provide the same to the people at large, either through visible notice or icons or something, and with or without permission sometime allow people to use it by giving a due credit to the original creator. As I said, it has a lot many types. There are six type of Creative Commons, which we often refer when we talk about the open resources. Acha, listen, this is I'm talking about open resources, which is also available freely to the people at large. So what exactly types of Creative Commons we have? The one Creative Commons is CC BY, which means you need to give proper attribution, allow others to distribute, remix, or and build upon the work even commercially, as long as credit is given. So you credit me as a creator, and then take the material, use it as you wish, and even commercially exploit it. So Khan Academy could be an example of that. CCBY, it's another method which we use this word. CCBY SA. CCBY SA means this is the second stage. Here, attribution is required and share alike. So we called it attribution share alike, which means it allow the others to remix, adapt, and build upon the work even for commercial purposes, as long as credit and license new creations under identical terms is given. So it requires some sort of licensing. Then there is a CC BY ND. ND means no derivatives. Non-commercial use is not possible. So you can use it, you can redistribute it, you can pass it to others, but what you are required to do, it can be only given by due credit, but not commercial purposes. Then there is a CCBY NCSA, which is non-commercial and share alike kind of CC Creative Commons. Then there is a CCBY NCND, which means it is again non-commercial, non-derivatives, meaning thereby give citation, share alike, but non-commercial, and it cannot be edited as such without any proper licensing system. So these are the 6 models which are available now. As a teacher or as a researcher, you may not be interested into knowing the details of that, but if you're interested, you can go to the Google and find out the details of these agreements. These agreements have a very standard format in which the author usually agree and then submit the material for the purpose or for under any one of these category. In a simple word, not going into the complicated phenomena, in a simple word, open access materials in India, especially CCBY materials, are available nowadays, and majority of the institutions, especially the law schools, they have started following this pattern. Let me tell you through my own example. The NLU Shimla, Himachal Pradesh National Law University Shimla, publishes as of now a total of 5 journals. Shimla Law Review, which is a UGC care journal. Then there is a HPNLU Journal on Environment and Disaster Management. Then there is an HPNLU Journal on Law, Business and Economics, HPNLU Journal on Taxation Laws, HPNLU Journal on Student Law Review, HPNLU National Law Review. So these journals, these 5 journals, go to our website, you will find they all are uploaded volume wise, the paper wise, and everybody can have an open access of that without any license, without any restriction on any sort of use, except the use which is required is the citation. And how will you understand? Every paper has a citation given, and it says as and when the paper is required to be cited, the citation pattern shall be this. This is known as open access material. Apart from that, there are a lot of other open access, fully accessible material, which I will discuss, I'll narrate in one of my slide, including the Coursera and including lot other free courses available online. Now, in data sharing, as a teacher, as a researcher, there could be sometime data sharing also. Data sharing is also requires an IPR intersection. If you have a certain data collected for your own purposes, and the same is required to be cited, then that is also having some sort of intellectual property interaction as such. Moving further, I hope I'm audible. If anybody can confirm. Is there anyone who can confirm if I'm audible? Dr. Tulika, if you are there. Anyone? Anyone there? Please confirm if I'm there, because I doubt if it is working.
Yes, sir.
Dr. Tulika, am I audible? I thought
Yes,
I
sir.
think
Yes, sir. Yes, sir.
was that disconnected for a while or it was working?
Yes, sir. There was some technical glitch due to internet.
Okay, okay. I hope I can. Continue now.
Yes, yes, you can continue, sir.
Okay, okay. Thank you. So I was talking about this slide. I thought at that point of time it got disconnected. So if you are into the data sharing, many times researcher collect data through field work. Researcher collect data through the other kind of collection tools, maybe primary data or secondary data, and they can share the data. There is a specific IP rights intersection there in the data sharing also. So when you are collecting, when I did my PhD on communal violence, I remember I collected data from three different states. And after 6 or 7 years, one news channel approached me that they want my data. I say the data is submitted to Delhi University. You can collect the data from there. As of me is concerned, I cannot share that data. The data is easily available in the Delhi University library. I'm not supposed to share with you because that is a kind of IP intersection. Thanks that I'm a student of Professor Alka Chawla, who have been wonderful teacher of IPR, who beautifully taught me how to minimally at least understand that what are the IP intersection when you are doing research as such. So here also, data sharing can interact you, can engage you into the sort of what we call as IPR and teaching academics as such. These things I have already discussed how what kind of role academic institution in IPR protection could be there. So here IPR cells are required to be constituted. I don't know if Dr. Tulika is already having IPR cell in the college, but if it is required, it is required to be there.
We
It is
have,
it is
sir.
must. Yeah, it is must. Second one, there should be a research integrity offices where we should monitor the ethical and other IP related rights, IP related intersections of the researchers, their concerns with the IPs, and they must be specifically trained for these purposes. Unfortunately, this is not very popular even in the present PhD system. If you see, there is a specific coursework on research methodology. There is a specific coursework on the developing laws and legal fields, and new there is a newly added topic on the issue of plagiarism. I think that aspect should be taken very seriously, where the plagiarism along with the IP intersection should be discussed in detail. So there must be an integrity office. Third, institutional policies must, and this policy must be a published policy. This must be available readily to every teacher, every student, every researcher, and in case there is a organizational collaboration, it must be available to the organizational things also for the purpose of general and outlining the scope of IP and research intersection. Uh, Another one, how to ensure that IPR rights are going to be protected properly. So you need to maintain the records of all sort of research process, ideas, and drafts. The strategy should be that kind of process, especially for patentability, inventions should be prepared in advance and must be discussed thoroughly with the IP office of the concerned institution. What kind of, if you are engaging into publication, what kind of contract would be there, what would be the liability of author, what would be the concerns and protection to the author, co-author, what if it is an editorial work published by the university, what would be the IP right of that, and what would be the contribution of organization. All these things must be there. uh, because these concerns today may be concerns of IP, tomorrow it may be concern of your own professional development. Again, I'll take my own example. I remember during my initial days when I enter into teaching field, I used to run from pillar to post to find out some good conference where I can present my paper. I'll not name the organization. In one of the conference where I presented my paper, the paper was published as a part of book published by the university without any ISBN number. Now, that paper I have published is worthless publication, at least from the point of what we call as publication as such, which fetch higher API as against mere attending a conference. I'm still getting only that small point, though that is irrelevant for me anymore at this stage of career. But point is that I'm thinking again in terms of a young researcher, a young teacher who would be publishing I mean, putting a paper in a conference, giving full-fledged paper, and the same is published as a part of whole book or conference proceeding without any ISBN number. These are the some small concerns as an organization and as a researcher you need to be aware of. So that's why I said understand the publishing contract. Review the publishing agreement carefully, especially clauses about copyright and licensing and the scope of IP protection into that. So this is again a kind of concern which comes to me with respect to the IPR. Now, the OER aspect which I have discussed, that aspect has lot of benefits. Not to go into that, it has a lot of benefit, and one of that benefit is easy availability. Uh, I'll show you that kind of OER resources which are available at this stage, like National Repository of Open Educational Resources, EPG Pathshala, Swayam, Vidya Mitra, NCRT eBooks, Consortium of Educational Communication, E-Shodh Sindhu, Digital Library of India, this is called DLI. So these are available. IIT Kharagpur has done a marvelous job in making these material accessible openly. Obviously, we're subject to all those 6 categories of type of licensing required in certain cases. Similarly, if you look into the global platform, what kind of global platforms are available? So MIT Open Courseware, Open Learn, another software, I mean, other website, OER Commons, OpenStax as a Rice University collaboration. Then Merlot is there, multimedia educational resource for learning and online teaching. Wikibooks is a part of Wikipedia, so Wikibooks are there. CK12 Foundation is majorly providing textbook for early level of studies. Then Sailor Academy is there. Library of Congress is there. These are the open book material which are available, open access material which are available on non-commercial basis. Similarly, in legal field, the approach of Government of India itself is very important. The www.judice.nic.in, if you visit the website, all the judgments of the Supreme Court are available on this website free of any kind of cost, and you can access the website. Similarly, every high courts these days are required to publish their judgments, their orders, their daily orders, their notices on their website. And not only that, if you go to the Judice and access the national portal, you will come to know that even there is a one single portal developed by the Government of India through which the district court's order, from a level of magistrate to the session court, high court, Supreme Court, everything is available there. Again, free of cost, there is no charge. And that helps a lot in terms of accessing the legal material, the law related law resources, and so on. So many journals have come as an open access. Judgments are already available as an open access. Majority of articles, majority of the papers you will find in the open access. Obviously, these days, commercial aspect is already there. So obviously, some material may not be. But there is a lot of material available in the open access. But remember, when I say OER, OER doesn't mean that you can use it as per your own whims and fancies. No, not at all. You will have to look into that what kind of OER is that. Is it only non-commercial use for that purpose available? Is it only used to be used by the researcher, by the teacher on non-commercial basis with citations? Or can they edit it also? Can they modify it also? That aspect is often mentioned on the top of the page only. For example, if you open any one of these three link which I have given here, the moment the link will be open, or at the top it is written whether it is CCBY NC, whether it is a CCBY NC essay, or what, it is written perfectly on the top of the page itself. And that will give you a very clear message that what kind of library or what kind of resource material it is. That will be a very, very helping hand in terms of OER, and how and to what extent you can copy, you can use it, and so on and so forth. So these are the some material which you can use for your own purposes. Now, as I said, I have just given you the outline of IPR teaching research. At the same point of time, there are a lot of case laws which has developed in India indicating about the attitude of inadvertentness towards the intellectual property right of others, and then being caught into soup or being caught into problems. I have just added 3 or 4 cases, such cases, which you need to look into. Dr. S. Krishna Kumar versus D. Shanta Kumari. This is a very interesting aspect of case law of 2018. A professor from Kerala, Mr. Krishna Kumar, accused his colleague, Dr. Santa Kumari, of plagiarizing his research work. The allegation was that Santa Kumari has copied significant portion of Dr. Krishna Kumar's research and presented it her own in the academic publication. The Kerala University constituted a committee to investigate the matter and found the evidence of plagiarism. The case is a very good case in terms of how these things are required, especially if you are making a research writing. In case of Nandini, a Madras University case, again here in 2019, a plagiarism issue was there when a professor was accused of copying the research article of his PhD student without permission. The professor allegedly presented the student's research finding in a journal without proper attribution. I can understand how the professor will cite the name of his or her own research student. Probably it is kind of maybe again same attitude of indifference. वो मेरा ही बच्चा है, मुझे क्या साइड करने की जरूरत है? That should not be the approach. This is a big case law on that point. That here, after internal inquiry, the university reprimanded the teacher, the professor, and the journal was directed to withdraw the paper also, and accordingly that was done. Further, a case from IIT Delhi, and these are some big institutions. I'm not talking about the tier 2 or tier 3 or tier 4 institution. I'm talking about tier 1 institution. Here, IIT Delhi, a professor was accused of plagiarism. Again here, of a junior faculty member and a PhD student. The allegation include using part of the junior professor's research work in published paper without giving due credit or co-authorship. Again here, the paper was retracted and the person was reprimanded here. There could be a possibility of even larger, things as well. I have just put a cartoon here to explain that point. See here, if you see, they never let you forget that your intellectual property belongs to them. So this is how you can see the copying has been done by both people, even when they are agitating against each other. Moving further, the Bangalore University plagiarism is, a scandal. It was, I would say, a similar scandal was there sometime in another college where more than 26 teachers in one go were punished for plagiarizing the documents of others. So this is how these cases are a reminder to us that we are supposed to take care of the IP policy as and when we are engaged into the research work. There are two, three leading cases because all those cases which I've discussed, they were at the university level. These are the cases where matter has reached to the courts, highest court of the law. K.K. Goenka versus Amit Goyal. The case involved alleged plagiarism of a copyright protected book written by the plaintiff, who accused the defendant of copying substantial part of his book to publish his own. The Calcutta High Court ruled in favor of the plaintiff, holding that plagiarism was evident as the defendant had copied significant and crucial part of his plaintiff's work. The court issued an injunction to prevent the sale and distribution of defendant's book. Eastern Book Company versus D.P. Modak is another case where the Supreme Court held that legal judgments themselves cannot be copyrighted as per they are the public document. The head note, footnote, and summary were the result of original labor and skill, and therefore they are protected by copyright. So if you are in your research work taking up the head note and footnote provided by the researcher like Eastern Book Company, like AIR, like Manu Patra, obviously they are having copyright. But if you are using the judgments per se, any paragraph, they are not hit by any sort of things, but they may hit by similarity index. Remember, if you are quoting the entire paragraph of any judgment and then without citing the paragraph and without making them in the quote unquote, then the similarity software Taunton or the Delbret or the Orcon will find it out and it will be rejected. So read the UGC guideline in this regard. UGC guideline says any expression of general in nature not beyond 13 words in continuity will be treated as a non-similarity parameter, non-similarity expression. But if there is even a general type of word copied from elsewhere or having similarity from elsewhere beyond 13 words, so almost 2 or 3 line almost, then they may fall under the similarity index as per the UGC guideline. Apart from that, UGC guideline says that if you are quoting any paragraph from any book or judgment or any kind of things, and you have given it in a quote unquote, which means that indentation format, then in that case that will be excluded. But that will be required to be excluded by the organization. Organization, if while checking it on Turnitin, if they exclude it, if they provide a policy in this regard, and that's why I'm saying every organization is required to have IP policy for the purpose of researcher, for the purpose of research writing, for the purpose of making study material, and so on. So Eastern Book case is a good reminder that obviously the judgments are not copyrighted material, they are open material, but if they are published by some sort of publisher, Eastern Book Company like SEC is Eastern Book Company publication. And if you choose the head note only, because head note are written in their own format, that is not part of any paragraph, that is a summary of any 2 or 3 paragraph or maybe summary of entire judgment, then that is copyright material. University of Delhi versus Rameshwari photocopy services case were very, very talked about case recently, somewhere in 2016. This was a kind of allegation case where unauthorized photocopy of books by Rameshwari Photocopy Services, which was contracted to provide course material for Delhi University students. The publisher argued that making photocopies of entire chapter from their book amounted to copyright infringement. Now, whether providing photocopy course pack for academic purpose amounted to the copyright violation or will fell into fair use, that was the case before the court. Delhi High Court has said, ruling in favor of the photocopy shop and Delhi University, holding that reproduction of work for educational purposes fall under the fair use provision of the Copyright Act. That the court emphasized that the role of education in India and deemed at that creating photocopy for academic use did not amount to plagiarism or photocopy copyright infringement. But remember, if that study material is going to be put on commercial use, then that can be subject matter of IP violation. So this is the discussion on IP intersection and the OER and the teaching, research, and professional things from my side. Now, if you have any question, any query, any sort of discussion, I will be more than happy. Thank you.
Yes, sir.
Yeah, please.
Sir, actually, due to heavy rainfall, we are facing some technical glitch. Just wait for
No
2 minutes,
issue.
sir.
No issue. No issue. No issue. Thank God there is a rainfall there at least. I think that may be a big relief from the heat and all. I'm here in Shimla, so obviously here the conditions, weather conditions are always different. But I since belong to the UP, I can feel, I can sense that. This is a very nice area you have chosen. Say my thanks and congratulations to the organizers. Uh, these are
Thank
the
you so
very
much.
less debated, less discussed areas. In
Yes,
fact,
sir, sure, sir.
yes, day before yesterday, we have been discussing about it amongst our teachers regarding certain circulation of material to the students. Sir, how do Creative Commons license facilitate the sharing of OER? Uh,
Yes, sir. How do
yeah,
Creative Commons license facilitate the sharing of OER? Just a
see,
minute.
creative, it's a
Hubab, Hubab,
uh, Rashid. That's a very nice question. The Creative Commons is a kind of agreement whereby the parties, the contributor, the creator, and the publisher, they come into one single forum and thereby agree that whatever contribution I'm making shall be subject to the open access to all. And in that agreement itself, they prescribe what will be the limit of open access. For example, when I publish, I'm editor of two journals at my HPNLU Shimla, HPNLU Journal on Law, Business and Economics, and HPNLU Journal on Taxation Laws. So when I accept the paper of any contributor, we send them an email that your paper is going to be published on the online way in our on our website and will be available through open access. And this will be based on what we call as just sharing and citation. Everybody is required to cite before they can use our journals. We use our paper published in that journal. That's how the Creative Commons is entering into. Now that is not required to be a registered agreement, not at all. We If you tomorrow publish a paper and if we screen and publish it on our website, the mail from my side and acceptance of that mail from your side will be treated as a Creative Commons agreement for the purpose of open access. So that is how the CC works as such. That's how the Creative Commons works. I hope I have answered your question, Rashid.
we have one more question.
Yeah.
How much does the various different countries' copyright laws affect the global sharing of OER, yani open education resources?
Yes, it does affect. It does affect. However, as of now, since these are very minimal in use, that's why we do not comment as such that how much it is actually affecting. But it is beyond doubt that since majority of the countries have their own municipal copyright law, and accordingly that creates a hindrance. In fact, WIPO, World Intellectual Property Organization, is doing a lot in this regard, and they are suggesting to the countries part of WIPO that please provide the kind of exceptions, maximize the kind of exceptions possible in your copyright, domestic copyright laws, so that these OER, these open access information can be put to use. And in fact, the one clause as of now which is popular across the world is the fair use doctrine. So that's how the things are going on. But as of now, it is not very formal as such at a world level. WIPO is trying its best, but as of now, it is not so popular. Yes,
Yes, sir. So one more question, and I think this is our last question.
no issue.
In what ways can OER contribute to achieving sustainable development goals related to education?
See, it's a very, very concerning question. Ayush Sinha. Uh, you know, one of the major area of sustainable development is the removal of poverty, the education, and especially the gender gap. Now, interestingly, these three aspects of SDG is closely connected. You cannot remove poverty without education, and you cannot remove gender gap without education. So gender gap, poverty, and education are a kind of circular relationship. They are in the circular relationship. If you need to break it, you have to address all the three concerns, and OER is one of the helping hand in this regard. Today, open access materials are available readily through OER, through these Creative Commons process, and majority of the people having internet access are having now access to a very quality reading material. I belong to the very, distinct generation, so not that old, but yet, during my time, the only way of reading any kind of quality material was to go in the library, the Allahabad University library, and limited space, limited number of books, and then availability of space and all. That was creating a crunch in terms of my hunger towards education. But now, while being here, I'm interacting with you. Being here, I'm interacting with a lot of other educators, and having the access to the Supreme Court judgments, and through my mobile phone, through my laptop. If a judgment is, I mean, this is amazing phase. Researcher and teachers, whosoever is there in this forum, let me tell you very openly and very frankly, we are living in a era of what we call as the most dynamic part of the world, and most progressive in a way that by 4:30, if a judgment comes, by 6:30 it is uploaded. And tomorrow, if I have a lecture, I can quickly go and get the information and update my student. I give you one more example. I'm teaching investment and security laws. I have just subscribed the newsletter of SEBI, and every evening by 7 p.m., SEBI sends me an email of entire new judgments, order, and notification they have passed on that day. So on a daily basis, I'm getting information from whom? The most authentic organization with respect to the security market regulations. What else I want? This is the what we call as a explosion of information outside. The only thing is whether we can use it or not, whether we are in a position to use it or not. So you just go, subscribe the newsletters. There are world across. I have discussed only a few type of OER. There are a lot of private bodies, like there is a something called Project Syndicate. There is something called Project 25. There is a something called Death Penalty Project by NLU Delhi. These two projects that I'm talking about, Project 25 and Project Syndicate, that is run by Nobel laureate Joseph Stiglitz. And any big research on economics, policy, women, gender, population in Europe, in America is easily available free of cost. And in fact, you will receive an SMS that this new publication has come. If you wish to read, please click the link given below. What kind of global information system has been set in front of us? Sometimes we may not be aware. So that is how the OER is contributing into the sustainable development goal also. And imagine one more thing: majority of these OERs are through the online mechanism, which otherwise is cost effective. Time management is possible. You can read at your own will and wish, and at the same point of time, ready availability. So I believe that OER, online information system, is providing a huge kind of push to the SDG policy.
Yeah.
I hope I have
Uh,
answered your question.
yes, sir. So thank you so much, sir. As we come to the last day of our faculty development program on the theme of integration of intellectual property right principle into teaching, research, and professional activities. I would like to take this opportunity to express our heartfelt gratitude to our esteemed resource person, Professor Dr. Gujesh Shukla sir. Sir, your expertise and insights into IPR and various other laws has been invaluable. Your ability to simplify the complex concepts and make them accessible to all the participants has enriched our understanding significantly. The knowledge you have shared about the latest trends and practical applications of IPR with open resources will undoubtedly empower us in our respective fields. Thank you for your engaging presentation and for sparking thought provoking discussions. Your passion for the subject was evident and has inspired all of us to delve deeper into world of intellectual property and other resources. I also want to extend, because this is our last session for 1 month faculty development program. So I also take this opportunity to extend my heartful thank you to all the resource persons we have and all the moderators and all the participants to be a part of this enlightening FDP and make it possible. We are truly grateful for the time and efforts your dedication to this program. Your contribution have made a lasting impact, and we hope to implement what we have learned in our academic and professional endeavors. Once again, thank you so much, sir, for your exceptional guidance and support. We look forward to the possibility for collaborating with you in the future, sir.
Thank you.
Thank you, everyone. Thank you for the
Thank
participation and enthusiasm throughout this
thank
FDP.
you.
Thank you so
Thank
much,
you,
sir.
Dr. Tolika. Thank you, Dr. Tolika. Thank you so much.
Thank
Thank
you
you.
so much, sir.